Hi, Tony DeWitt here, Missouri Appellate attorney and a guy who tries to make the law make sense on YouTube. Today we're going to talk about a motion that, quite frankly, often gets lawyers in trouble. And it gets them in trouble because sometimes they get over their skis and it can just be a real mess. So let's talk about the motion to compel down at the beach. The motion to compel is designed to force one side or the other to turn over documents or permit inspections of property and that sort of thing. Now, I know this will absolutely amaze you, but the fact is that when a plaintiff or a defendant sends a request for production, in other words, please produce all emails between the plaintiff and the plaintiff's doctor, I know that it will come as a grave surprise that sometimes people do not comply with that request. And they might have a valid reason if medical confidentiality was truly an issue. But people will cite medical confidentiality, but they won't actually have much of a case if the doctor's testimony is going to be admitted at trial. And for that matter, if the medical records are going to come in at trial, because they've already waived medical confidentiality as a part of getting their case decided. So given that there is a problem with somebody making a false assertion of privilege, the defendant in that situation will file a motion to compel. And normally it works out something like this. They initially send the discovery request, a request for production, and the plaintiff has 30 days in which to respond. And of course, a response can include an objection. So what the plaintiff does is they object on the basis of medical confidentiality and send the request back to the defendant. And the defendant writes them a nice letter, sometimes referred to as a golden rule letter, because we have to do unto others as you would have them do unto you. So in this golden rule letter, you say, look, I realize you've asserted medical confidentiality, but perhaps you didn't process the fact that you've already waived medical confidentiality because you've put the plaintiff's condition at issue in this case. And so if the plaintiff's counsel has, a good command of the law, he will go, yeah, right, should have known that, and then produce those emails. But if not, if, for example, he asserts the doctor's right to keep his email private, then he may write a letter back and say something to the effect of, well, I was not trying to protect my patients, my client's rights of confidentiality. I was trying to protect the doctor's rights of confidentiality because, let's face it, he has a right to be secure in his communications, and he didn't file suit. He hasn't waived anything. So now you have the issue where they've asked for something. The defendant believes that he has an absolute right to get it. The plaintiff is saying, no, you don't have an absolute right to do that. Now they have to go to the judge. But in federal court, what has to happen first is something called a meet and confer. Now, in a day where we have cases with lawyers from across the country litigating claims all over the country, it would be a little difficult for all of the parties to jump on a plane and go to a central point to have a meeting about a series of documents like these emails. So either the meet and confer is conducted by phone or by Zoom, but either way, it is conducted. And then if the parties remain stalemated, they take the issue to the judge. Now, sometimes this can get very, very far out of hand. Let me show you a court order here in a case where the judge essentially calls the parties to task for failing to get along. And it's kind of a beauty, and you can tell the judge has a bit of a sense of humor.
Minute entry before the judge. Already the court has been contacted several times about the nature and scope of the hearing on 1/12/23. That's fair. Here's what's not anticipated. The court's not holding an evidentiary hearing or expecting sworn testimony with witnesses. But here's what will happen. Counsel must come prepared to discuss in detail how to best move forward with the plethora of pending and anticipated motions in a manner consistent with the federal rules of civil procedure, as I will explain to the court why this case appears to have gone so far off the rails on so many levels and in so many different ways, despite Judge so-and-so's Herculean efforts. For those of you who are parents, I'm stopping the car. When a judge has to be this direct and this upfront about what he's feeling, it's generally an indication that neither party is going to get a lot of what they want.
Just because the judge has a bit of a sense of humor and believes that people are fighting over things that might not really be important at the end of the day, each party has a right to have its issues determined by the judge. And whether he likes to do that or not, the judge will ultimately be called upon to decide certain issues. What he's trying to get them to do, I think, is to decide these issues in a way that doesn't involve the trial of the century or a hearing in front of him where he listens to two lawyers whine about each other. So that's how it's done in federal court, this meet and confer requirement. But in state court, oftentimes what happens is the judge will either make a determination based on the motion papers, or there will be a hearing. In fact, in Missouri, the way it works out is I file a document that says I want the defendant's communication with the co-defendant in this case. And the defendant says, hey, we've produced all of the information. I then go into the courtroom and say, okay, as you can see, Judge, here we have a situation where for 17 months, when they were in this business together, there were email communications 2, 3, 4 times a day between these two principal parties. The lawsuit was filed here, and after that date, there's a period of 6 weeks where there is not a single email produced. And you would then say to the judge, it defies imagination that they didn't speak for that when they spoke all this time before. And of course, at that point in time, the defendant would come in and say, well, Judge, we're not saying that there's no communications there. We're saying that all of those communications are attorney-client privilege. And the judge would then say, well, where did you list all of these communications on your privilege log? Well, we didn't really feel like we needed to do that. Well, you do need to do that. Make a privilege log and submit it to me. So what is a privilege log? A privilege log is a listing of the documents. Email from Joe Blow to Tom Smith. Date, 3 April 2021. And subject, redacted. Well, they will list each one of these emails, and then they will also have to list who was on the email chain. So in order for the documents to be attorney-client privileged, they can't just copy an attorney on their personal communications about the case. They have to not copy their attorney, because if they copy the attorney, it does no good. An attorney-client privilege is sort of like a car. One person owns that car. One person has the keys to that car. You don't get to share the car with somebody else. That lawyer is the lawyer of one party or the other, and that lawyer has a attorney-client privilege with his client. But he doesn't have an attorney-client privilege with the other person, the other defendant, who has his own counsel. And you waive that privilege where you copy a party who is a party to the lawsuit, but who is not represented by the same attorney. But anything that copies anybody who is not represented would be a waiver. Now, you have to understand that particularly where you have a defendant that is a company or a corporation. The corporation is the client. And so even though the email copies the chief financial officer, the chief information officer, and the janitor on the third floor, those people are members of the corporation or employees of the corporation, and the attorney-client privilege attaches to the communications with them as well. So that's how a motion to compel works. A person asks for something in discovery, they are denied something in discovery, and then the person who is denied goes to the judge, asks for relief, the judge gets involved, makes a determination whether or not the document should be produced, and as a result, an order is entered directing that happen. Now, another way that a motion to compel can be filed is because of deposition answers. Somebody goes to a deposition and, please state your name for the record. Well, I'm Joe Blow. Okay, Joe, how long have you worked at the company? I'm asserting the Fifth Amendment. I don't wish to incriminate myself. So usually what will happen at that point is they'll call the other lawyer outside and say, hey, you need to talk to your client. How long he's worked at the company, it has no way of incriminating him. And if the lawyer is a good lawyer, he'll take him back and say, hey, look, you can't assert the Fifth Amendment here. Tell me what you're worried about being prosecuted for. And a lot of times witnesses will say, well, I'm not worried about being prosecuted for anything. What I'm worried about is having to testify, and I don't want to do that. You can't use the Fifth Amendment in that way. But the other thing that's perhaps even more important is you can't selectively invoke the Fifth Amendment. You can't answer questions you want to answer and then not answer questions that you don't want to answer. Let me make sure I have that right. You can't answer questions you wish to answer and then turn around and invoke the Fifth Amendment to not answer a question you don't want to answer, and then later on again say, well, no, I'll answer that question. You can't do that. So one of the things that happens, of course, when someone asserts the Fifth Amendment in a civil deposition, it doesn't apply in a criminal case, but in a civil deposition, if somebody comes in and asserts the Fifth Amendment, then the jury gets to think that, well, a truthful answer to that question would very likely incriminate them. So, obviously we can take that for what it's worth. Now, sometimes lawyers are just a little bit too smart for their own good, and they will encourage a witness to take the Fifth Amendment because there may indeed be a criminal case that's sort of laying in the bushes waiting to pounce. We had that happen in a situation involving a wrongful death claim where employees of a nursing home some of them were simply cruel. And so as a result, a lot of them would take the Fifth Amendment. Because they would take the Fifth Amendment, one of the lawyers who was taking the deposition would say, okay, so you're not going to tell me how long you've worked here okay, that's fine. So isn't it true that you have a $500 a day drug habit? Whether it's true or not, the guy is not going to answer that question. And if he does answer the question, he again can't selectively invoke the Fifth Amendment. So the guy just asked question after question that indicated this person was an awful individual, and as a result of that, they quit doing the Fifth Amendment for most of the witnesses because the fact was that even though there was a potential criminal case, nothing had been filed. And eventually a criminal case did get filed, but it was filed against the principals in the organization, the CEO and the CFO. So, and then of course the testimony of the lower employees was not particularly relevant on those criminal issues. Motions to compel are useful because they can provide complete discovery. If somebody has refused to answer an interrogatory question, you can force them to answer that. If someone has refused to produce a document, you can force them to produce that. If someone has refused to answer a question in a deposition, you can make them do that. In that way, you can get pretty much all of the information that you need to determine whether you have a case or whether, for example, you may need to settle the case if that's at all possible. And that applies both on the plaintiff side and the defense side. So that's what I have for you today. The motion to compel, again, very useful. It can be used to ensure that you get the information that you need to prosecute a lawsuit. The motion to compel is very useful, can get you the information that you need, but it can also sort of irritate the judge. So you have to be careful, particularly in pretrial, where legal issues get decided, not to do too much of the irritate the judge thing, because eventually that will come back to haunt you. Today, let me suggest to you that if you have the opportunity, that you make a small donation to a charity of your choice. St. Jude's Children's Cancer Research Center is a good charity. There are a number of excellent charities out there that do some really good work. And in an environment where costs are going up and inflation is crippling certain people financially, the ability to make even a small donation is an important thing to do. It helps advance science, particularly in the case of the St. Jude issue. But even if it's just to the local food bank, even if you just pick up some lima beans out of the cabinet that you know you're not ever going to eat because you hate those disgusting things, even if you just do that and take it down to the food bank, it'll give you a good feeling. So thank you so much for watching. If you have any comments, leave them in the comments down below. Like, share, subscribe, you know all that stuff we ask you to do. Thank you again, and have a marvelous day. I will catch you down here at the beach next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.